like to read that is in it's a quoted authority miscellaneous application number 58 of 2018, James Agri Orengo and 11 others versus Director of Public Prosecutions and 2 others. In this case, Your Honor, from the reading of this paragraph, there was summons that was requiring the applicant's attendance before the Chief Magistrate Court at Nyeri, in Nyeri, for purposes of taking plea. That was sought by the first and the second respondent. Again, does not apply to this case. As I conclude, Your Honor, the advocate for the first respondent has submitted that the first respondent is the Director of Lake Basin Authority and a presidential appointee. I would like to submit that everybody is equal before the law. All the respondents, the state is treating them the same. Irrespective of your social standing in the society. Lastly, I will not allude to the issue raised about politics. I have nothing before us to enable us to submit on that line. That is our submission. I am most obliged.
No, we are not objecting. You proceed.
Your Honor, Yes. Your Honor, on the outset, I'm supporting the DPP with regard to this application. It's good to state it from the outset. Your Honor, my colleagues, especially the advocates for the first respondent, has made heavy weather of Section 67 of the CPC. Your Honor, the marginal notes of that section talks about accused persons. The persons before you are respondents. So that section does not apply. Your Honor, I have to cross-reference on an application which you have already ruled on. That is of the one Philip Aroko, which my learned colleagues brought before you. Your Honor, you'll recall, because just a few minutes ago, they were demanding that Aroko be brought here.
You know, I didn't want to
Come on,
object.
come.
No, hold on. I didn't want to object to my senior, save that the court has pronounced itself on Aroko matter. If the court is functus official, what we are seeking for is purely the question of jurisdiction. On the 5, not plus Aroko. That's it.
Yes, my Vina, you are right. The court has pronounced itself on that.
Thank you.
I'm just cross-referencing. That application.
No.
Yes.
That's not the issue.
Yeah.
If he was going to be brought here, we were going to make the same application. Huh?
Yes. So, yes. So, Your Honor, it was premised on the fact that there was an alleged violation of rights, and that particular individual was meant to be brought here quickly. So, my colleagues are talking from the two sides of the mouth. Bring, when they are brought, no, down your tools. Your Honor, I've just cross-referenced that, and it's true, as my learned colleague has said, you have already ruled on that, but you can take note of that kind of warped submissions. Your Honor, lastly, I would like the court to take judicial notice of another related application before this court, E077 of 2025, which this court granted the same orders that the ODPP is now seeking. Your Honor, taking judicial notice of that, we urge that you grant the prayers of the DPP, since they are...
No, we do have jurisdiction, because we are dealing with whether I have jurisdiction.
Exactly,
Prayers.
exactly. But you have to take judicial notice of...
What I'm saying,
Yeah.
you say that grant the application, but I thought we are able to get the application, we are on whether I have jurisdiction.
Yes. And you can it's the same thing, Your Honor. You have jurisdiction and you must grant it. Since you've granted it before. Yes. You've granted it before. And you take judicial notice of the proceedings that I've just indicated. Lastly, Your Honor, Your Honor, that particular proceedings is coming before you on 5th. The same proceedings I referred to, on 5th of May. Lastly, Your Honor, 5th of June. Lastly, Your Honor, the advocates of the first respondent is actually urging this court to countenance the violation of the rights. And I want to explain of the respondents. They are submitting that you down your tools because you don't have jurisdiction, so that the respondents can go back with the police and then later on argue that their rights were violated because they were held beyond the same 24-hour rule.
How can you imagine?
The same 24-hour rule that they are making heavy weather of. Your Honor, I submit that you have jurisdiction. That's all.
Yes, Aribato, my good friend, my senior, Apollo Mboya has put his arguments through. A proceeding has been mentioned that this court had. If the question of jurisdiction was not raised, either due to the counsels who were present, I don't know if there were counsels, or the people who are unrepresented, failure to tell the court that it has no jurisdiction does not confer jurisdiction to a court. The court, on its own motion, on suo motu principle, could have refused that application. We believe the court dealt with that matter because the state never disclosed full disclosure of where the offense happened and which court has jurisdiction. That has been laid bare before you. So, Your Honor, it is our position that a court that has been dealing with matters, 1,000 matters, does not get jurisdiction by the number of cases it has handled. Jurisdiction is conferred by the Constitution and by statute. And we have demonstrated that. Number two, my good brother is telling you, if you don't deal with this matter, the respondents will be detained by the police. This court is above threats and intimidation. The court should stand firm with the law. If it has no jurisdiction, working hours for courts in this country start at 8 to 5. Courts with jurisdiction are sitting now. The courts are in operation, and the state ought to take these respondents to where the court has jurisdiction. Your Honor, an attempt for you to do an illegality is a serious, serious issue that each court clothed with jurisdiction deals and protects itself. Don't be told that the respondents will suffer. There is no great injustice than a respondent being dealt with at a court that has no jurisdiction. And lastly, my good sister, Madam Monunga, Your Honor, the DCI and the DPP are our friends, so the public might think that we are enemies. We are simply working. Let it go to the whole world that we work together with the DCI and work with the DPP. Save that then they are the other side, they are on the other side and we are on this side. Ms. Onunga never told you which provisions deals with the respondents. They are talking that these are not accused people. If you read it, it does not talk about respondents. Arrested persons. Arrested persons, according to the law, is this a trial? Very well, that's what I'm saying. Is this a trial? is, what is a trial? A trial is a competent court sitting, a competent DPP prosecutor sitting, a suspect, an arrested, an accused person. Otherwise, if it is not a trial, the DCI would have dealt with this matter administratively in the DCI offices. The moment they appear before a judicial officer, it is a trial. And that proceeding or trial, the court will be called to make a determination. Courts only make determination when proceedings continue and rules of procedure followed in those proceedings, which is completely different from the Directorate of Criminal Investigations procedures, which fall under the police standing orders. We are before a constitutional organ called a court of law. You will hear us, you will make a determination. Your determination can be challenged to the High Court, to the Court of Appeal, and to the Supreme Court. What else can be said that is not a trial? The court will render its judicial mind on this matter. Judicial officers are to render their independent minds after hearing both parties. So, Your Honor, anybody trying to say these are arrested persons, entry of anybody to appear before you is an arrest. Entry for any person to appear before court in a criminal matter is an arrest. And that's what you are saying, that let the court exercise its mind. That these people before you are before you as people who deserve to be dealt with within the law. Mr. Mbeta will deal with that.
Proceed, yes. Yana, you are being told that this is not a trial. You are being told that these are not accused persons. You are just being told that they are just respondents. But do these respondents have rights? Yes, they do. And their fundamental rights start running from the moment they are arrested. From the moment they are arrested. And they run so that we prevent this kind of problem that we are facing now. told that the reason why we are blowing hot and cold is that we were demanding another person to be brought to court within 24 hours. Yes, we are demanding that he be brought to court before 24 hours.
My lady, are we still discussing jurisdiction here? Or have we
It is
moved
a
on to
point
other
that they
issues?
raised about my learned colleague, Mr. Apollo raised, so I cannot let it slide. Yes. Had he been brought in this court today, Your Honor, that could not have stopped us from making this application that we are making now. We would have done it. But then, the authority I gave the court, that is number 166 of 2020, Health Enforcement versus Republic. If you go to page number 10, the second paragraph, and this is the judge's opinion, which then the state intentionally, and if not intentionally, by design, have avoided to tell you. And what does it say? The Director of Public Prosecution has a statutory obligation to commence or institute any criminal proceedings. Next paragraph number 2, where it starts in intimately in connected foundation, section 71 and 72. Is the doctrine of
What page?
Page 10. Page 10.
paragraph second. Yes. The Director of Public Prosecution has a statutory obligation to commence or institute any criminal proceedings in terms of Article under 157 of the Constitution within the local courts where the offense was committed. Obligation within the jurisdiction where it was committed. But what they forget is the next line, to give you exceptional circumstances. What have they given you as an exceptional circumstance? What have they given you? And Your Honor, they have given you nothing. Are these proceedings in a court? Yes, they are. And if they are in a court, which is the court that is supposed to have started these proceedings? We are saying the court that has jurisdiction, that is the one. That is why we are asking you, Your Honor, then what grants you the jurisdiction in this matter? Where do you get the jurisdiction? It is what they needed to give you to aid you to respond to that. They still give you nothing. Anything that comes to court must be tested. Whatever they say in the affidavit is tested. Whatever the IO and the prosecution give is tested. Is that not a trial? Are we not trying something? That is a trial by any way of imagination. My learned sister and good friend, Mr. Muga, said clearly that they agree that jurisdiction is everything. But she tells you this is premature. Yet we have suspects in court. What is premature about it? Because in the first place, the commencement of this matter should not have been here. But now that they brought it here, what is premature about it? They just use words and it is premature and leave it at that, and everybody is supposed to imagine. They are telling you the persons in the dock have not yet been charged. But Justice Nyakundi in that same application says commence that when the state wants to start any matter, the director of the state jurisdiction to commence or receive any criminal proceedings, it must be within that jurisdiction. Now we are saying, is this not a criminal proceeding? Did the DPP follow the rules of what he has said? But an attempt has been made that anybody arrested with anywhere can be taken to court, even the nearest one. I want to just imagine that any of these accused persons was arrested around JKIA. Your Honor, no. Not even one of them was arrested anywhere, even imaginary, around here. The respondent in court today, the first respondent in court today in this application, was arrested in Nakuru. They did not take him to a court in Nakuru. They rushed him to JKIA. Another one was arrested in Langata. Kibera is the nearest court, but they brought him here. And Your Honor, then that is why the questions are coming up. Why do they want to do this? Even when they know the law is clear, why do they want to do this? Your Honor, while we are saying that the suspects have been brought within 24 hours, isn't it also their right that they be tried within the jurisdiction that they are supposed to be tried? But my learned colleague, Mr. Apollo, watching brief for the family, is it? Yes, tells you that this matter, you have the jurisdiction. Where does he get that authority to tell you that? Because he did not quote anything, he just said it for the sake of saying it, just to feel that. He said it for the sake of saying it. Because if he had any backing, today Mr. Apollo, who I know and is my learned friend and a very good friend, I know him very good with the law. Yes, I'm coming to that. And that is why I'm coming. No, that is where I'm coming. That's where I'm coming, because I know him to be very meticulous, always with authorities, always with the law, and he carries them in briefcases. But today, he comes with an empty hand and tells you you have jurisdiction based on it. And then he tells you you've handled the other matters before. Does that give him the right to just assume and tell you to do things for the sake of, or does it give you any jurisdiction? Either way, it does not work. And some of the authorities that I bring in court, he gives me. And then they give you two wrongs, and then they tell you that please proceed. So they want you to just proceed. And you're being told by my learned colleague, Ms. Onunga, that evidence can be scattered all over. If evidence is scattered all over, is that the basis of jurisdiction? That is not the basis of jurisdiction. It is where the accused person is arrested or the scene of crime, not where evidence was found. That again is being said for the purpose of just emphasizing an non-existent law. Yana, and this I will say very humbly, because when we come to court, we come so that this court can arbitrate. And we come because we know that this court is a protector, not only of the persons who are in custody, but also of the law. So when you find a prosecution has come here and they are giving you stories that are not based on anything, and apart from quoting for you Article 49 and 36.
When I object, we're not giving stories. What I was submitting backed by the law. Kindly, Counsel, please correct that. No stories. I cannot bring stories to a court of law.
The only one that was not a story is Article 49 and 36. The rest of it was imagined.
We don't give imaginations in court.
Yes, Your Honor, when you're told that evidence is scattered everywhere, what evidence did they even give you? If that is not an imagination. A good story. The DCI would have finished this matter at the station if it was that simple. But the reason why the law removes these things from them is so that they do not misuse that power of theirs. And now the DPP, when these gentlemen say they want to bring the case to JKIA, the DPP keeps quiet and says, yes, please proceed, it is okay. One time I used a word that everybody objected to when I said that they were behaving like rascals, and they said it was an insult. But the word rascal just means behaving in a cheeky way. And behaving in a cheeky way means you are disrespecting, because those definitions, if you look at them, it means you are respecting. So when I say the DCI and the prosecution today are rascals, and the rascals are the DPP and the prosecution, let me allow Shadrach to proceed with the rest.
No, we can't allow Mr. Obeta to insult the state.
No, Your Honor.
Yes.
Today, if you take Simu, Fungua Dictionary, it's Oxford.
Black's
The
no
definition
dictionary.
of rascal, it is there.
No, Your Honor, we will not check that. And it's not necessary.
It is
we will not add to the facts of their case.
What is rascal in definition?
It will not add value to the case, to their case.
No, no.
By calling the state rascal, no. That is very offensive. Yes, that is very offensive.
I think you are also saying that support, I don't know that it was Sandra, for talking about, even though they are watching us online, should also be able to see the listing of rights. So please, don't use a language that we know, it's an insult in this.
Soma to dictionary. But you want me to withdraw?
No.
Okay, let me withdraw, but you know what is in my heart.
And apologize.
Yes, Your Honor, just a few comments. My name is Stanley Kinyanjui. And the only reason for me, Your Honor, to rise is because I believe we are marking the waters for ourselves. You know, I say this because, you know, the days of finding ambiguity in statutes through the employment of semantics is long gone, Your Honor. And I say it's long gone because, Your Honor, the law has provided us with tools of statutory interpretation. And I am afraid what our colleagues in the DPP are doing are riding on the construction of statutories. Construction of statutes, Your Honor, sorry. That is, finding the wording and the meaning of such words through reason and logic. They are telling you that simply because a statute does not capture the word respondent. Then there's a lacuna in law. But Your Honor, if we go holistically,
On that aspect, especially the content arrested. Did you give them under the rights of arrested?
yes, Your Honor, I'm only echoing what my senior in the DPP was saying. And that is the reason why this court cannot apply section 67, 71, and the subsequent sections of the CPC. Simply because there is no word as respondent. In that statute. At this point, I wish to humbly say that I think they might have forgotten that in statutory interpretation, Your Honor, we have what we call the legislative purpose. And the legislative purpose, Your Honor, goes on to assist us to understand the mind of the drafters, the problem posed to the mind of the drafters, and the solution offered. Your Honor, my colleague has directed this court to the heading of section 71, which deals with the inquiry and trial. So I will pose this question to this honorable court, Your Honor. That if indeed the drafters of the CPC, in their own wisdom, and the wisdom fetched anywhere else, so it fits to limit the exercise of arraignment of an accused person or any other person arraigned before a trial court, they did not wish to limit the jurisdiction, that is the territorial jurisdiction of such court, then why are there the provisions of 67, 71, and 72 of the CPC? Your Honor, it has long been held that the rights of an arrested person being a right enshrined in the Bill of Rights.
Your Honor, I thought this had already been raised earlier.
Sorry, just, Your Honor, it's if the DPP can just follow my flow of thought. I'm trying to right a wrong here. Your Honor, if we go back, then this court is mandated to give an interpretation that gives the greatest benefit to whoever claims that right. and that is the right to a fair trial, expeditious, and the Honor will note that in the case of Republic Ex parte Wanjigi, that is application JR application 84 of 2018, which was given to you earlier. There is the citing of the case of the Union Bank of the Philippines and Desi Thomas. That is page. Then it's paragraph 62. I can't see the pages at the bottom or at the top, but at paragraph 62, there is the citing of the case of the Union Bank of the Philippines and Desi Thomas versus people of the Philippines, that says that the reason for this rule, that is the rule to try and hear any case within a proper territorial jurisdiction, the reason is first, that the jurisdiction of the trial court is limited to well-defined territories, such as a trial court can only hear and try cases involving crimes committed within its territorial jurisdiction. Second, laying the venue in the locus criminis is grounded on the necessity and justice of having an accused on trial in the municipality of province where witnesses and other facilities for his defense are available. Your Honor, I wish this court not take so much mind as to the semantics of the accused person. Yes, Your Honor, but Your Honor, we know that this is a case in the Philippines, so they use different terms as we use. They use different terms. Yes, that's why Your Honor, I've said, I hope this court let it not delve into the semantics of that particular sentence or that particular paragraph. Yes, Your Honor. But even as we look at the authority, let us look at what it says. And Your Honor, this court is allowed to adopt it with the necessary modifications. So much so that if municipality in the Philippines translates to Nairobi County, here we have Kibera Sub-County, Kibra Sub-County, Starehe, and very many others. So, Your Honor, I'm asking this honorable court to reject that mischievous invitation by the DPP, because in essence, yes? Yes, mischievous invitation by the DPP and the DCI to allow what we are doing here today. Because, Your Honor, the next thing, nothing will stop the DCI from arresting someone who is in Mombasa of a crime happening in Nyali and arraigning them in Kisumu.
Nairobi is Nyali.
It's Nyali, I'm saying Nyali. And Your Honor, I'd wish, as I sit down, to employ the principle of discerning problems and problem solving. In particular, Your Honor, the Occam's razor, comes RESA, that is OCCUMS. RESA, that the simplest answers are usually the correct answers. So let us not engage in semantics about respondent, accused, and such things. Thank you.
So I've been given authorities which I know I'll not be able to read them right now. I need time to study them. So what I'll do, I'll deliver a ruling. Yes.
What I want to ask, with the direction of the court,
Yes.
we were here to look at this application of extension of time. We can make the ruling as a well-rounded ruling. As we are making a decision on jurisdiction, you can also hear us on this application so that once you go back to your chambers, you make a full decision on that issue. Otherwise,
No.
you'll be coming back again and you'll have to do this whole process again.
Jurisdiction is the entry point. It is either I have jurisdiction or not.
That is how
If I have, I proceed. If I don't, I down my throat. Yes, but now I need time to look at these authorities and what both sides have stated. So I'll deliver a ruling on whether this court has jurisdiction or not tomorrow. That will be 9th of May at 10 a.m. What I want the guidance from the state is where we should remand, because I need to give an order for them to be remanded. I know in your application I have seen it. You insisted that they be remanded at different police stations, but at this point we are yet to decide on whether I'm giving custody on that or not. Can you put them in the same station and, for the night?
Well, if it's already in different stations, we will let that status quo to remain as such.
Okay. So the area is aware where each was. So we take them back to where they were for the night. Then tomorrow, depending with what the court decides, the court now will make a decision.
The
Yes.
families and the lawyers will want to know where they were. Let it be disclosed to the court so that it is known where they are.
They are going to
So
be
that the
for the
families
overnight.
can see.
Okay.
We have no objection when you remanded where they were, but let it be public information.
So we can, with the guidance of the IO, yes, we can just have if prosecutor, you can say if it's first respondent, second, and fourth, fifth. We take them back to the same stations before now we go to the main application. First respondent, where they were brought to from as we are coming here. You can start with first respondent.
The first respondent
Yes.
was the
Langata.
Yes, Your Honor. The second respondent was at Gigiri police station. The third respondent was at Pangani. The fourth respondent was at Kiambu police station. Then the fifth respondent was at Embakasi police station.
So the first respondent, the London, the police station, they were being held. This is to it, Garnata, Gilili, Pandani, Kiambu, and Embakasi, respectively.
And in the meantime, you know, they can have access to family and their rights.
That's okay. There's no problem with it. But I know when you are dealing with such high level cases, because I think it's not the first time I'm handling such high level case, caution must be exercised to the respondents. Don't allow anybody to visit you. Don't. Yes. So even as Council 3 for Better says that a family be around, take caution yourself. Don't allow anybody. And that's why sometimes we say whoever wants to see them, kindly liaise with the IO respectively. Not everybody will come to see you as a friend, especially when you're doing such high end. So kindly ensure that the person seeing you has been vetted by the IO first, for your own safety and security. As much as your advocates may want you to be seen by anybody, from where I sit, I won't see no. It's not safe for you. Yes, let them pass through the IO. Alternatively, the advocates to accompany the person coming to see you for your own safety. Okay. So, okay, see you tomorrow. God willing.